Hi, everybody. This is Attorney Wilberforce Adjunct at Ivy Law Office. Today, I want to talk briefly about a situation with a client that we just assisted to receive his green card and his I-485 approved. This wasn't easy. Initially, our client received a notice of intent to deny, and he had to respond to that. Uh, a quick backdrop. What happened was that the client had previously married an American citizen, but in this particular case, he had been petitioned for by his current spouse, who's also an American citizen. The previous marriage ended in divorce, and that is the marriage that led to the notice of intent to deny, not the current marriage, which there was no issue because the client's current marriage was with an American citizen. They had a home together, they have children together, so there was no issue. The issue, again, leading to the notice of intent to deny, was the previous marriage. And so, what my client faced was potential deportation based on the previous marriage, which USCIS alleged to have been fraudulent. So this was a serious problem because he was literally facing the possibility of having to either leave his family here and return back home to Nigeria on his own without his family, or the family would have to all relocate to Nigeria, even the children who were born here as U.S. citizens. Although they could remain, obviously they could not remain without their parents. So that's where we were. And I'm going to give you a little backdrop in terms of what the officer alleged and found that constituted, in his view, the marriage fraud. Okay, so there it is. The officer says the beneficiary married the petitioner on August 25th, 2016, in New York City, New York. On September 20th, 2016, uh, the petitioner filed a petition for alien relative from I-130 on behalf of the beneficiary. And the beneficiary filed an application to register permanent residence or adjust status from I-485. On August 3rd, 2017, the petitioner and the beneficiary appeared for a USCIS interview. During the interview, it was clear that petitioner and beneficiary did not share the basic knowledge of one another that would be expected from a married couple. Petitioner did not know how many times Mr. Beneficiary was previously married. Mrs. Petitioner also did not know if Mr. Beneficiary had been petitioned for before, and she had never met or spoken to Mr. Beneficiary's children, did not know where, uh, and Mr. Beneficiary did not know where Mrs. Petitioner lived before moving in with him. He claimed that she resided with her mother and that her mother still resided at the same location, but he did not know Mrs. Uh, uh, where, but he did not know where she resided. Mr. Beneficiary stated that he thought Mrs. Petitioner's parents were divorced, but he was not sure. Regardless, he did not know where her father's whereabouts. Beneficiary also did not know how much income Mrs. Uh, Petitioner earned or what she did with her pay. Finally, it was noted that petitioner and beneficiary entered entered the interview with their own separate papers and kept their papers separate throughout the interview. Not looking good so far. Moreover, USCIS. Now, this is the part that was an issue for us. Moreover, USCIS records reflect that the beneficiary's previous spouse, the petitioner, was married to two other men while she was married to the beneficiary. And she filed immigrant visa petition for all three men. As set forth above, petitioner married the current beneficiary on August 25th, 2016, and filed a visa petition for him on September 20, 2016. Petitioner married a second man on October 27, 2016, and filed a visa petition for him on March 20, 2017. She then married a third man on November 1, 2016, and filed a visa petition for him on December 23rd, 2016. She claimed to reside in marital union at three different addresses with each of the three beneficiaries at the same time. Petitioner also appeared for USCIS interviews individually with these beneficiaries on August 3rd, 2017, on February 15, 2018, and March 22nd, 2018. Petitioner did not disclose any prior or other marriages on any of the visa petitions or during the USCIS interview. These events, according to the officer, constitute substantial and probative evidence that the beneficiary engaged in marriage fraud for the sole purpose of obtaining an immigration benefit. That was a tough one to read when the client came in. In view of the foregoing, USCIS finds that the approval of your Form I-130 is prohibited under Section 204C of the Immigration and Naturalization Act. You have 30 days from the date of this notice to submit additional information, evidence, or arguments to support the petition. Failure to respond to this request within the allotted time will result in the denial of the petition. So, as you can clearly see, this was a serious matter for the client. And we had to respond timely and effectively. And in our case, as you can see by what I just read to you, he was facing some problems and potential deportation based on that prior marriage, which was in question. However, as you can see from the officer's own letter, my client, there wasn't much in the letter to ascertain whether or not he engaged in any fraudulent conduct. But surely there was plenty enough to suggest that there's a high probability that the U.S. citizen was engaged in fraudulent conduct, and my client and these other immigrant men were the victims of a U.S. citizen who apparently preyed on these men, and therefore an argument could be made that indeed our client did not engage in any fraudulent conduct, but indeed was a victim of the fraudulent conduct of the United States citizen's spouse. And so it was a strong case, and we made our arguments. We used the statutes, and we were able to, at least on some level, convince the officer that our client did not intend or, in fact, commit fraud in this instance, in this case, and therefore should reverse the findings and the intent to deny, which I'm happy to say on behalf of my client and his family, the officer indeed reversed that, and they grant our client the I-130 approval and the I-485 adjustment of status. Well, that's what we do. This is serious, and these cases are important and significant and can be life-changing, life-altering, either for bad or for good. And we do our best to deliver for our clients the good. And in this case, our client has won their case, and it gets to remain in the United States with their family and continue to build their dream and add to America and society as a whole. So if you need help, if you received a notice of intent to deny or other requests for evidence from USCIS and you need assistance responding, please contact our office. Contact me, Attorney Wilberforce Adjicum, and I can help you. Our phone number is 301-276-0887. Again, 301-276-0887. Or you can reach us on our website at www.ivylawoffice.com. Okay? And we'll be happy to help you. All right. Thanks for joining me, and we'll see you again next week, if not before that. All right? Bye-bye.